I'm sorry? Ma'am, put the groceries down and step away from the cart.
I'm sorry? I'm paying for these.
We received a report of a woman concealing items.
I scanned every single
Store
thing.
security says you're acting suspicious.
Suspicious or black?
Watch your tone. My name's...
The parking lot of the Prestige Foods grocery store on Peachtree Industrial Boulevard in Dunwoody, Georgia, was quiet on a Tuesday afternoon in September. It was 2:14 p.m. The lunch rush had long cleared out. A few cars drifted in and out. The automatic doors slid open and closed in steady rhythm. Nothing about the afternoon suggested that within the next 47 minutes, a chain of events would begin that would end 2 law enforcement careers, cost a major retail corporation $4.1 million, and trigger a Department of Justice investigation into the Dunwoody Police Department. Angela Reeves had stopped at Prestige Foods on her way back from a deposition in Buckhead. She was still wearing her court attire, a deep navy blazer, matching slacks, cream blouse, pearl earrings. Her briefcase sat in the back seat of her black Audi Q7. She needed 3 things: sparkling water, almond milk, and something for dinner. She figured she'd be in and out in 8 minutes. Angela had been shopping at this particular Prestige Foods for 6 years. She lived 4 miles away. She knew where everything was. What Angela did not know was that Marcus Webb, the store's loss prevention officer, had been watching her from the moment she walked through the door. What Marcus Webb did not know was that the woman he was watching had personally prosecuted 94 criminal cases in Georgia courts, that she had secured convictions against 11 law enforcement officers for civil rights violations, that she had argued before the Georgia Supreme Court 4 times and won 3 of those arguments, that she had been awarded the Georgia Bar Association's highest honor for public service 2 years running, that she was, at that exact moment, 3 weeks away from being nominated to serve as a federal judge. Marcus Webb saw a black woman moving through a grocery store, and in his mind, that required watching. This is the story of what happened next, and I promise you it is going to leave you speechless. Before we go further, I want you to drop a comment below and tell me where you're watching from: your city, your state, your country. This community matters, and if you believe that accountability is not optional, not for civilians, not for corporations, not for police officers, hit that subscribe button right now, because this story is far from over. Angela Reeves grew up in Macon, Georgia, the second of 4 children born to Earl and Dorothy Reeves. Earl worked the line at a Tyson chicken processing plant for 22 years. Dorothy drove a school bus and cleaned office buildings on weekends. They were not a wealthy family, but they were a disciplined one. Dorothy Reeves had a saying she repeated so often her children could recite it in their sleep. Nobody can take your education. Not the economy, not bad luck, not anyone who looks at you and decides before you open your mouth that you are less than you are. Angela absorbed that lesson like oxygen. She was the kind of student who filled her notebooks with color-coded annotations, who read ahead of every syllabus, who asked teachers questions after class not because she needed clarification, but because she was curious beyond the curriculum. Her high school English teacher, Mrs. Patricia Doss, later told a reporter, Angela didn't just learn things, she interrogated them. She wanted to understand why a thing was true, not just that it was. Angela graduated as valedictorian of her class at Howard High School in Macon, earning a full academic scholarship to Spelman College in Atlanta. At Spelman, she majored in political science with a minor in philosophy, graduating summa cum laude with a 3.98 GPA. From Spelman, Angela went directly to Emory University School of Law, where she became one of the first students in the program's history to win both the Moot Court Championship and the Law Journal's Best Note Award in the same academic year. She graduated in the top 2% of her class. What drove Angela toward law, specifically toward prosecution, was not ambition alone. It was something more personal. When Angela was 15, her cousin Darnell was arrested in a case of mistaken identity. He spent 11 days in Bibb County Jail before the charges were dropped. No apology was issued. No one was held accountable. The actual suspect was never found. Angela watched her aunt hold her son after he was released, the look on both their faces, relief tangled with something that had no clean name. She decided then that she wanted to be the person inside the system who made sure the system had to answer for itself. After law school, Angela joined the Fulton County District Attorney's Office as a junior prosecutor. She spent 3 years there, building a reputation for surgical case preparation and an almost unsettling composure in the courtroom. Judges noticed her. Defense attorneys respected her. Other prosecutors studied her closing arguments. She was recruited to the Georgia Attorney General's office at age 31. By 35, she had been promoted to lead the Public Integrity Unit, the division responsible for prosecuting government officials and law enforcement officers accused of criminal conduct. In 4 years leading the unit, Angela had secured convictions against 2 county commissioners for bribery, 1 state trooper for evidence tampering, 4 police officers for civil rights violations, and a sitting judge for obstruction of justice. That judge had called her personally after sentencing, from somewhere between fury and disbelief, and said, "You're going to make enemies." Angela had replied, "I already have." At 39, Angela was widely considered the most effective public integrity prosecutor in Georgia history. The governor's office had quietly reached out about a potential appointment to the Northern District federal bench. The nomination process had begun. Angela had said nothing publicly. She continued doing her job. She had no idea that a Tuesday afternoon grocery run was about to become the most significant legal battle of her life. Marcus Webb had worked loss prevention at Prestige Foods for 4 years. He was 26 years old, had a certificate in retail security management from an online program, and had made 43 shoplifting stops in his career at the store. 31 of those stops had involved black customers. He had never flagged that statistic. Neither had his supervisors. Webb's training materials specified that loss prevention officers should only approach a customer when they had directly observed the customer select merchandise, conceal it, and pass the final point of sale. That 3-step protocol existed for a reason. Without all 3 steps, there was no probable cause. There was only assumption. Marcus Webb did not observe Angela conceal anything. He did not observe her select merchandise with the intent to steal. He observed a black woman in professional clothing moving through the store with a cart, scanning her items at the self-checkout. He watched her pay. He watched a green confirmation screen. He watched her receipt print. Then he called Officer Derek Walsh. Officer Derek Walsh of the Dunwoody Police Department had been stationed at the Prestige Foods location as part of an off-duty security contract, a common arrangement where retail stores pay officers to patrol in uniform. Walsh was 41 years old and had been with Dunwoody PD for 14 years. His disciplinary record included 2 sustained complaints of excessive force, both of which had been handled internally. A 3rd complaint, filed 8 months prior, was still under review. Walsh and Webb met briefly near the customer service desk. Webb told him he believed a customer had shoplifted. Walsh asked no questions about what Webb had observed. He did not ask whether Webb had seen concealment. He did not ask whether the customer had passed the final point of sale without paying. He simply said, "Where is she?" Angela was gathering her bags from the self-checkout counter when the store manager, a man named Philip Garrett, appeared at her side. What followed was the opening exchange you heard at the beginning of this story. Angela's receipt was in her hand before Garrett finished his first sentence. She had paid $34.17 for 4 items. She had the paper confirmation, she had the digital receipt already synced to her phone's grocery app. She had been standing in full view of 2 ceiling cameras and the self-checkout's built-in camera the entire time. None of that mattered to Officer Walsh.
Walsh took a position between Angela and the exit. A second officer, responding to Walsh's radio call, entered through the side entrance. The store had gone quiet in the way places go quiet when something is happening that everyone can feel but no one is addressing directly. Angela Reeves had litigated enough cases to understand exactly what was occurring. She had prosecuted officers who had done exactly this. She knew the legal framework. She knew her rights with the precision of someone who had written briefs about those rights for a living. She also knew something else. She knew that being right was not the same as being safe. And she knew that the anger building inside her chest needed to stay exactly there, compressed and controlled while she documented everything. She asked Walsh clearly for the basis of his suspicion. He cited a report from store loss prevention. She asked Walsh whether loss prevention had observed all 3 elements required for probable cause under Georgia law: selection, concealment, and passing the final point of sale without payment. Walsh said he was following up on a report. She presented her receipt. Walsh said the receipt could have been produced fraudulently. Angela looked at him steadily and asked whether he was aware that the self-checkout system's digital transaction records were time-stamped, camera-verified, and synchronized with the store's inventory management software, making fraudulent receipt generation functionally impossible at this location. Walsh told her to keep her voice down. Angela's voice had not risen. She was speaking at the same measured register she used in courtrooms. She informed Walsh and Garrett that she was the Assistant Attorney General of the state of Georgia. She produced her Department of Law identification, her Georgia Bar Association card, and her driver's license. She laid all 3 on the cart's child seat, where both men could read them clearly. Philip Garrett looked at the Department of Law ID. Something shifted in his expression. He started to say something to Walsh. Walsh told Garrett to let him handle it. What happened in the next 4 minutes would be captured by 6 cameras, 2 ceiling-mounted, 1 at the self-checkout station, 1 from a customer's phone, 1 from the body camera Walsh was required to wear, and 1 from Angela's own phone, which she had begun recording the moment Walsh took his blocking position. Walsh told Angela she needed to come with him to the back office for questioning. Angela asked whether she was under arrest. Walsh said she was being detained for investigation. Angela cited Terry v. Ohio and informed Walsh that an investigatory stop required reasonable articulable suspicion of criminal activity, which he had not established and could not establish given that she had a receipt, the transaction was digitally verified, and no concealment had been observed. Walsh said she was being uncooperative. Angela said asserting constitutional rights was not uncooperative behavior under any case law in any jurisdiction in the United States, and she would be happy to provide citations if he needed them. Walsh told her to turn around. Angela looked directly at Walsh's body camera. She stated her name, her title, the time, the date, the location, and the names of every person present. She said, in a clear and even voice, "I am being unlawfully detained without probable cause or reasonable articulable suspicion. I am complying under protest and duress. Any charges filed as a result of this detention will be the basis of a federal civil rights action under 42 U.S.C. Section 1983 and a criminal referral under 18 U.S.C. Section 242. She was taken to the back office in handcuffs.
In the back office, Angela sat in a metal chair across from a folding table. Walsh's second officer stood near the door. A camera mounted in the corner of the room recorded everything. The footage would later be described by a federal judge as among the most clear-cut documentation of racially motivated unlawful detention I have encountered in 14 years on the bench. Angela asked once more for the specific articulable facts that justified her detention. Walsh produced a written statement from Marcus Webb that said he had observed a customer matching Angela's description acting suspiciously near the premium items aisle. The statement did not allege concealment. It did not allege passing the point of sale without payment. It said acting suspiciously. Angela read the statement. She looked up. This statement does not allege any element of shoplifting under OCGA Section 16-8-14.
It contains no observation of concealment, no observation of intent to deprive the store of merchandise, and no observation of passing the final point of sale. This statement is legally insufficient to establish probable cause or reasonable suspicion for any shoplifting-related offense. Officer Walsh, you are holding me in this room on the basis of a document that would be thrown out by any first-year law student in Georgia. Walsh told her to sit tight. He stepped out and called the station. What happened at the station in the next 11 minutes mirrored almost exactly what had happened the night Diana Lawson was detained in Sacramento. Dispatch ran Angela's identification. The results came back immediately. Angela Reeves, no warrants, valid license, current Georgia Department of Law employee, title Assistant Attorney General, Public Integrity Unit. The watch sergeant called Walsh directly. The call lasted 2 minutes and 30 seconds. Walsh came back into the room and told Angela she was free to go. Angela did not move. She said, "I want every officer's badge number. I want the name of the loss prevention officer who filed the report. I want to know the name of your watch commander. I want the incident report number, and I want this facility's complete camera footage preserved and held pending a legal hold order, which will be delivered to corporate counsel for Prestige Foods within 72 hours. She stood, gathered her 3 grocery bags, which had been sitting on the table the entire time, and walked out of the back office, through the store, and into the parking lot. She sat in her car for 6 minutes before she drove away. Those 6 minutes were not inactivity. Angela was dictating a voice memo, a detailed chronological account of every exchange, every name, every badge number, every timestamp she had observed. 23 years of legal training converting trauma into evidence before the adrenaline had a chance to obscure the details. She called the Attorney General of Georgia from the parking lot. He picked up on the second ring. She told him what had happened. There was a long pause. Then he said, "Get me everything you have. We're moving tonight." By that evening, Angela's account was in the hands of the Georgia Department of Law's Civil Rights Division. By the following morning, a legal hold order had been sent to Prestige Foods Corporate Counsel, demanding preservation of all camera footage, transaction records, loss prevention logs, and personnel files related to the incident. By Thursday, the FBI's Atlanta Field Office Civil Rights Division had opened a preliminary inquiry. The story reached the press on Friday. A WSB-TV reporter in Atlanta broke the news with the headline, "Georgia's top prosecutor for police misconduct handcuffed at grocery store." By Saturday morning, it had been picked up nationally. By Sunday, it was international. The body camera footage was released by court order the following Monday. It ran for 47 minutes across multiple angles. The legal community watched it with the specific horror of people who recognized every mistake, every missed off-ramp, every moment where a different choice could have changed everything. A professor from Georgia State University College of Law went on CNN and said, "What you're watching is the legal equivalent of a surgeon getting misdiagnosed at their own hospital." She cited every relevant case from memory. She documented in real time. She preserved evidence before she even left the building, and she still ended up in handcuffs. The civil lawsuit was filed 11 days after the incident. Angela's attorneys, a team led by her law school classmate and renowned civil rights litigator Danielle Cross, filed a 61-page complaint naming Officer Derek Walsh, the city of Dunwoody, Marcus Webb in his individual capacity, and Prestige Foods Corporation. The complaint alleged unlawful stop and detention, false imprisonment, racial discrimination in violation of 42 U.S.C. Section 1981, civil rights violations under Section 1983, and negligent supervision and training by both the Dunwoody Police Department and Prestige Foods. The complaint included a data appendix. Danielle Cross had subpoenaed Prestige Foods' internal loss prevention records going back 5 years. The data showed that black customers at the Dunwoody location were stopped by loss prevention at a rate 3.8 times higher than white customers. Of the stops involving black customers, 71% resulted in no charges because no theft had occurred. Of the stops involving white customers, that number was 34%. Marcus Webb's individual record showed that 73% of his stops over 4 years had involved black customers. His supervisors had never reviewed this data. When deposed, the regional loss prevention director admitted he had never analyzed demographic patterns in stop data across any of the chain's Georgia locations. The Dunwoody Police Department's data told a parallel story. Black residents in the 3 zip codes served by the department were subjected to investigatory stops at 2.9 times the rate of white residents. Officer Derek Walsh's individual stop data showed that 68% of his discretionary stops he initiated rather than responded to, involved black individuals in a city where black residents made up 19% of the population. Walsh had 2 prior sustained complaints of excessive force. Both had resulted in mandatory retraining. Neither had affected his employment status, his access to off-duty security contracts, or his ability to carry out enforcement duties without supervision. The FBI's formal investigation was announced 6 weeks after the incident. Over the following 8 months, federal investigators reviewed more than 6 years of Dunwoody PD records, interviewed community members, analyzed use of force reports, and examined patterns in stop data, search data, and complaint disposition records. The 187-page report, released in May of the following year, documented what investigators described as a pattern and practice of racially discriminatory enforcement within the Dunwoody Police Department. The report identified 41 incidents over 6 years in which black professionals, attorneys, doctors, educators, executives had been stopped, detained, or questioned in circumstances that the report described as lacking any articulable non-racial basis. In 38 of those cases, internal complaints had been filed. In 35, those complaints had been classified as unfounded by Internal Affairs. In all 35, the investigating officer reviewing the complaint had been a colleague of the subject officer. The FBI report made specific findings about Officer Derek Walsh, citing his stop statistics, his prior complaints, and the specific conduct captured on body camera footage during Angela's detention. The report described Walsh's justifications as post hoc rationalizations unsupported by any contemporaneous articulable facts. The federal indictment was handed down in March. Walsh was charged with deprivation of rights under color of law under 18 U.S.C. Section 242, unlawful detention without probable cause, and conspiracy with a private party to violate civil rights, the last charge relating specifically to his coordination with Marcus Webb. Webb was charged separately with civil conspiracy to violate civil rights under federal law. Walsh's attorney filed 4 motions to dismiss, arguing that Walsh had acted in reasonable reliance on Webb's report. Each motion was denied. The court found that reasonable reliance on a third-party report did not exempt an officer from the constitutional obligation to establish independent, articulable suspicion, especially when the report on its face described no legally sufficient basis for detention. The trial began in September. Angela testified for a day and a half. She was composed, methodical, and precise in a way that clearly affected the jury. She explained what it felt like to be handcuffed in a grocery store after 23 years spent inside the law. She said, "I knew every case that should have protected me. I knew the standard. I knew the precedent. I cited it in real time, and I was still put in handcuffs. That is not a failure of my knowledge. That is the system telling me with absolute clarity that the rules applied differently depending on who was walking through the door." She paused, and I decided that day that I was going to make sure that moment cost something. The jury deliberated for 2 days. Walsh was convicted on all counts. Webb was convicted on the conspiracy charge. At sentencing, the federal judge said, "Officer Walsh, you had a receipt in front of you. You had verified identification showing this woman's title and employer. You had a legal hold analysis presented to you verbally in plain language that should have resolved any ambiguity. You chose to proceed not because the evidence supported it, but because you believed you could. That belief that you could is precisely what these laws exist to punish. The sentence of this court is 8 years in federal prison." Marcus Webb received 18 months, with the court noting his cooperation with federal investigators after indictment. The civil settlement with the city of Dunwoody was announced 4 months later, $2.8 million, with a consent decree requiring independent monitoring of the Dunwoody Police Department for 5 years, mandatory retraining of all loss prevention activity at every Georgia location, mandatory retraining of all loss prevention personnel, and the creation of an independent oversight committee to review stop data quarterly. The settlement with Prestige Foods Corporation was $1.3 million, with a separate consent decree requiring demographic auditing of all loss prevention activity at every Georgia location, mandatory retraining of all loss prevention personnel, and the creation of an independent oversight committee to review stop data quarterly. Philip Garrett, the store manager, resigned before the settlement was finalized. Marcus Webb's employment had been terminated the week the lawsuit was filed. Dunwoody's chief of police announced his retirement in the same week the FBI report was released. 2 captains and 3 supervisors were demoted or separated from the department in the following 6 months. The off-duty security contract program was suspended, pending a full review. Angela donated $800,000 of her settlement to 3 organizations: the Southern Center for Human Rights, the Georgia Justice Project, and a scholarship fund she established in her mother Dorothy's name at Spelman College, specifically for Black women pursuing careers in public interest law. She kept the rest for Maya and for herself because she had earned it. The federal judicial nomination process, briefly paused during the investigation, resumed. Angela was confirmed to the United States District Court for the Northern District of Georgia 9 months after the grocery store incident.
At her investiture ceremony, she stood before a packed courtroom in a robe that cost $47 at an Atlanta consignment shop and said simply, "Justice is not a noun, it is a verb, and every day it requires someone who refuses to be convinced that the work is finished." Officer Derek Walsh is currently serving his federal sentence. He will be eligible for release in 6 years. His pension was forfeited at conviction. His law enforcement license was permanently revoked. His name now appears in Georgia's POST Council database as permanently decertified, meaning he can never again serve as a law enforcement officer in any capacity in the state. Marcus Webb completed his sentence. He has not returned to loss prevention work. The Prestige Foods location on Peachtree Industrial Boulevard installed new training protocols, new camera systems, and a new loss prevention oversight structure. It also installed, at corporate's direction, a small plaque near the customer service desk that reads, in simple lettering, "Every customer deserves to be treated with dignity and respect." No one knows if anyone ever reads it. But Angela Reeves now sits on the federal bench less than 12 miles from that store. And the officers and executives who put her in handcuffs have learned the same lesson that Kevin Brennan learned in Sacramento, that loss prevention officers across the country are beginning to understand, that departments and corporations and institutions that have coasted on unchecked bias are confronting in courtrooms and consent decrees and federal investigations. The lesson is this: bias does not check credentials, but accountability does not either. Angela stopped to get sparkling water, almond milk, and something for dinner. She left with all three. She also left with a receipt, a voice memo, and the clearest sense of purpose she had felt in 23 years of practice. Some people say she was lucky that she had the knowledge, the resources, the title, the presence of mind to fight back.
Angela has a different word for it. She calls it prepared. And she will tell you, without hesitation, that preparation should not be a prerequisite for dignity. That every person who has walked through a store or a neighborhood or a gate or a parking lot and been treated as a suspect for the simple act of existing while black, every one of them deserved the same outcome. The difference is that Angela Reeves had the tools to make accountability happen. Her mission from the federal bench is to make sure those tools become available to everyone. Thanks for watching this story all the way through. If it moved you, if it made you angry, if it made you think, that is exactly the point. Share this with someone who needs to understand what racial profiling actually looks like when it meets the full force of the law. Subscribe, because we are not done bringing you stories that expose injustice and prove that accountability is possible. One final question. Do you think 8 years was enough for Officer Walsh? What does real accountability look like where you live? Drop your answer in the comments. Let's keep this conversation going.